Good morning, Fiona here on a Legal Affair Radio. Today, I am bringing you a digest of the latest courtroom gossip circulating Sydney. Yesterday, former Chief Justice Spiegelman said to one of our sources, "It is common for witnesses to confidently assert the truth of conversations, observations, and events which did not happen." Well, are false memories or ignorance the new fad? We have a few experts to join us in answering this question and to enlighten us with their knowledge and experience of the court. And you are in luck because the man himself, James Spiegelman, is here to guide us on this fascinating journey into evidence law.
Hello, Fiona. Thank you for inviting me to speak on this podcast.
And joining us as well, we have a bright and upcoming lawyer, Verity Laws, who has kindly lent her time to attend several trials in the district court to give first-hand accounts of the law in action. Welcome.
Thanks, Fiona. It's a pleasure to be here.
Before we get on to the nitty-gritty, can you please remind our listeners about the rules of examination in chief and cross-examination?
Certainly. As we all should be aware, in New South Wales, the Evidence Act of 1995 dictates what legal practitioners can and cannot do during court proceedings. For example, Section 28 gives us the order of questioning in which the trial is conducted, the examination in chief followed by the cross-examination, and very rarely a re-examination. Of course, it is primarily the prosecution that conducts the examination in chief, as the defense does not need to make a case. The defense therefore has a slight advantage in being able to attack the prosecution's case by cross-examining the witnesses. In fact, a dear colleague of mine, Judge Refshaw, has stated that cross-examination is the greatest legal engine ever invented for the discovery of the truth. Of all the criminal trials that I have attended this past month or so, only the prosecution has produced. As for the re-examination of witnesses, I've only seen one trial, R. and Thomas Peter Lowe, where this occurred on several occasions. A forensics officer in charge of fingerprint evidence, a sergeant detective, and a constable. So that's how infrequent it is. Whether this can be taken as a statement of how truthful witnesses are from the beginning remains to be seen though. Section 29 allows for the general rule for questioning witnesses by party and managing their response. Important to note that the court may, in its discretion, control any part of this process under the broad powers given by Section 26. And from experience, we judges hardly use this, except when it is obvious that a line of questioning may be dubious. We lawyers hope it stays that way. The majority of cases I've seen have had very minimal input from judges through Section 26, so we are relatively free to do as we please as given by Section 27.
So what you better have referred to is witness questioning, which of course is what the examination in chief and cross-examination are all about. Why is there such an emphasis on it?
The Australian criminal trial relies heavily on oral testimony from witnesses, especially eyewitnesses, as they are taken to have been at the scene of the crime and therefore would accurately recount the details of what had happened. As was discussed in Hadid and Redpath, it is an opportunity for witnesses to have their words evaluated and are therefore not discredited if they have not been seen or heard by the court. However, whether they are actually truthful, remains to be seen, but the Evidence Act provides safeguards to assist in our endeavour to uncover the truth, however legally constructed it may be. Yes, what is important is not that the actual truth be found for either the prosecution or defence to prove their case to the jury or judge. As Judge Dawson mentioned in Whitehorn and the Queen, the trial does not involve the pursuit of truth by any means, but is rather dependent on a judge's ability to balance between the contending parties. What makes this interesting is that this process of finding a constructed truth requires truthful witnesses.
Quite interesting indeed. Then given the importance of having witnesses give accurate testimony of the events that occurred, how does the questioning system aid with that?
Firstly, usually require the witness to swear an oath or make an affirmation in accordance with Section 21 before they give any testimony. It's hoped that this would make the witnesses more truthful, as it gives a sense of heightened seriousness of the matter and the consequences of willful lying, that is, committing perjury whilst on the stand should, in theory, deter even the most serial of liars. This was observed in R. and Drea Branch, where the witness admitted to being untruthful in his police statement. So far, there hasn't been a case that I've observed where the witness has not sworn on the Bible.
Speaking of witnesses, there are usually a large number of potential ones. So how does the court decide whether to allow a particular witness to testify in the first place?
As I mentioned earlier, the Act essentially has a list of do's and don'ts when it comes to admitting evidence and questioning. The overriding characteristics of the evidence are that of relevance and credibility, as long as it satisfies the test set out in Section 55 for relevance and meets the exceptions of the credibility-only purpose under Section 103. The witness is able to give evidence. Also, my colleague Judge Simpson in R and LAZ observed that there was a substantial standard of assessing credibility. She said evidence under Section 103, subsection 1 must have the potential to have a real bearing upon the assessment of the appellant's credibility. As can be seen, the credibility assessment is held to a high standard, as was found in R and Lockyer.
In fact, there was a case that I attended during a voir dire, R and Abdullah Sadat Jogamasi, where some evidence was not able to be found, and Judge Norris disregarded the need to find it due to a lack of relevance to the current case. Of course, this also applies to considering whether witnesses should be questioned or not. As for the credibility issue, all the testimonies I heard were directly related to the facts in issue in each trial, such as a witness being cross-examined in relation to being unable to see events occurring due to darkness, as was the case in Lowe, or witnesses being questioned on the specifics of the events which led to the accused person being charged, as was the case in R and Matthew John Baker.
James, you mentioned earlier that the Evidence Act has safeguards that helped with the truth-finding purpose of questioning witnesses. Could you elaborate further on them?
Certainly, Fiona. It follows that apart from the rules of admissibility, there are also procedural rules that guide questioning of witnesses. Section 41 gives the court powers to disallow improper questions. Undoubtedly, if such questions were allowed, it would waste the time of all parties whilst failing to address the actual issues. For that reason, the High Court in the case of Wakely said the judge should intervene to prevent such an undue strain on the hearing and determination of a case.
For example, in Lowe, the judge questioned the defense counsel for asking pretty random questions to the witness during cross-examination, like repeatedly asking about loaves of bread in the backyard of a crime scene.
Furthermore, although leading questions are necessary in the interests of justice, as was found in R and Coffin, Section 37 restricts the use of leading questions during an examination in chief, as it is suggestive of an answer to the witness, rather than letting the witness explain in his or her own terms. Canadian case, R and Gordon Bredsky addressed leading questions that related to issues that are immaterial should be avoided, as it would impair the weight to testimony of the witness. However, Section 42 allows them for cross-examination purposes. Of course, the court has discretion in both cases to either grant or disallow them.
From my observations, only the cross-examiner asked leading questions. For example, in Baker, the defense was allowed to put towards the witness an alternate version of events, whereas the prosecution was only able to ask about established facts, such as where the witness was on the day of the crime. By questioning in this manner, we are able to ensure that the witness is doing his or her best to give accurate testimony by aiding the truth-finding process.
Wow, there do seem to be a lot of restrictions. But what happens in the case where the witness just forgets, or even when the person doesn't even know that he or she is lying?
You have touched upon a quite complex subject here. Of course, with so much reliance on the honesty of witnesses, there lies a huge risk when witnesses remember events incorrectly or even state a lie whilst believing it to be the truth. Whilst there is not much that we can do, the court does allow for witnesses to use documents to refresh their memory in court through Section 32. The court also allows for evidence to show for prior inconsistent statements under Section 43. Similarly, Section 108, subsection 3b, permits evidence of the witness's prior statement in cases where testimonies are suspected to have been fabricated or reconstructed.
Time and time again, I've seen that often witnesses just don't remember the exact details of what happened at the time of the event, especially if they are not the direct victim. In Baker, the witness repeatedly could not give specifics when asked about what had occurred, often answering with, "I don't know," or "I don't remember." Her memory did seem jogged when listening to a recording of the 000 call that her daughter made to the police. However, this also raised questions about her memory, since she had testified that she was the one who had made the call. In fact, this issue was specifically raised in R&BJS, where the defense counsel stated that memory is an unreliable instrument that can be tainted by an unreliable narrator. Even with the Evidence Act to guide the parties, it is inevitable that there would be impediments to the truth-finding process, as our criminal trial is reliant on potentially untrustworthy evidence.
That is certainly quite troubling to hear. Now, I know our listeners must be dying to hear more wise words from the great former Chief Justice and the helpful insights by Verity. Unfortunately, we have run out of time. Thank you once again for listening to our podcast. It was a pleasure having you both.
Not at all, Fiona.
The pleasure is mine.
For a more comprehensive list of the trials that Verity attended, please refer to our website. I hope you all have enjoyed the show. This is Fiona Liu of Legal Affair Radio signing out.